Well, good morning. It is truly an honor and a privilege to be here. I want to thank the organizers of this symposium, Sam Calhoun especially, and all of the people who've made this very hospitable time here. I'd also like to compliment so many of the presenters. It's truly been outstanding. Don't agree with everything that everybody said, though I found myself in disturbing agreement with a lot of Caitlin's premises, and we'll get to that probably in the question and answer period. But I think it is important to be able to disagree without being disagreeable. I'm afraid that some of what I will say will be disagreeable to people, but I hope that that flows from the content and not from anything personal or from my manner, though I do tend to get agitated about these issues. The origin of my talk goes back, 25 years. 25 years ago, I wrote probably, I think it was my second law review article ever. I was invited to participate in a symposium honoring the life of Robert M. Cover. Bob Cover, was one of my law professors at Yale. And he was actually my supervisor on that third-year writing program, you know, that sort of onerous task that law students have to get through. But he made it a delight. He and I did not agree on political things, and we had the best discussions in his office. We argued passionately about everything important in life: law, politics, religion, baseball, and had a great good time. He died in 1988 or 87, I believe, at age 42 of a heart attack. And my contribution to that symposium, is before I became a law professor, it was a write-in symposium in the Journal of Law and Religion, was an extended book review of this book he did that I picked up while one of his students. It wasn't assigned, right? I actually went out and bought the book at the local bookstore to read a book that my professor had written. It's called Justice Accused: Anti-Slavery and the Judicial Process. And his entire theme was the conflict presented, what he called the moral formal conflict between anti-slavery judges who were called upon to enforce pro-slavery law, and just sort of the conflict and the dilemma and some of the evasions or the frontal assaults. And it was really my first thorough introduction to the constitutional law of slavery. My article was doing some comparisons and saying, I wonder if the moral formal conflict for judges today who are pro-life, who are anti-abortion, is similar, and I was investigating the conflict presented for anti-abortion judges called upon to enforce pro-abortion law in the form of Roe versus Wade, and sort of examining it through the lens of constitutional interpretive methodology, some distinctions and some similarities. Well, actually, that article was sort of the launching pad for two distinct lines of my scholarly career over the past 22 years. I've written about a half dozen articles on the law of slavery, civil war, secession, the constitutional law issues associated with the Civil War era in the 19th century were just fascinating to me. I love them. This is a good place to be to discuss those. Except that I brought my copy of Lincoln's speeches and writings. Sam, is it okay to quote Lincoln in Lexington? So I've written about a half dozen articles in that line, and I'm also a passionate pro-life advocate. And I've written about a half dozen law review articles on various issues involving abortion, its intersection with constitutional interpretation, and many related issues. And occasionally these two seemingly disparate interests intersect, as they did back in 1989 in that early law review article. And that's kind of the title of my topic today, is the insistent analogy to slavery. Now, the analogy to slavery is, of course, not only insistent and persistent. Many people have drawn it. But it's also one that's probably unwelcome to pro-abortion partisans. Like the very notion that their defense of abortion rights, self-styled as and doubtlessly sincerely believed to be progressive, pro-civil rights, pro-women, pro-liberty, pro-equality position. The suggestion that that might be compared to the most universally condemned anti-progressive, anti-civil rights, anti-liberty, anti-equality, legal and political position imaginable, slavery, is for such persons, I do not doubt, offensive in the extreme. Yet the analogy I submit is an insistent one. It's a comparison that insists on careful attention and consideration that has a great deal of validity on many specific points. It also should be, for anti-abortion or pro-life advocates, equally a disturbing analogy, because despite the fact that it's far less unwelcome analogy for the pro-lifers than it is for those who hold the pro-choice position, it suggests that those who espouse the pro-life views, anti-abortion views, have been a bit too tepid, complacent, and therefore to some degree complicit in a legal and social evil of a magnitude and horror whose closest American legal and political analogy is the colossal, embarrassing, despicable moral evil of American slavery. We are living, I submit, in the midst of what is arguably the greatest moral holocaust in the history of humankind. And, you know, that'll be an offensive statement to some, but half of the people in this room, or at least the speakers, actually embrace that as an affirmative right, and the other half seemingly tolerate it or acquiesce in it, at least to some degree passively accept it, which was actually much was the case as with slavery. I do not doubt much of what Caitlin says about American public attitudes. Most people would prefer not to have talks about abortion, and most people would prefer the issue to go away. This was also the case in the 1820s, 1830s, and 1840s, where those who pressed the anti-slavery position were regarded as cranks, irritants, busy-bodying moralists, you know, who were just sort of intruding their views upon a stable and secure, prosperous nation. Really, don't we want to talk more about internal improvements and growth of the economy than slavery? And similarly today, about abortion. What I'm going to do in the next 20 minutes or so is sketch out in broad brush terms what I think of as sort of the four large analogies between the arguments for slavery and the arguments for abortion rights. First, I'll talk about the stakes, the similarity of the stakes between these two issues in the different centuries. Then I'll talk about the structure of the moral argument for abortion rights and for slavery rights, and note their parallelisms there in just terms of the rhetorical structure. Then I'll talk about the constitutional legal structure and the really striking parallelisms that exist there. And finally talk about some of the implications for the moral formal conflict. What is your view of the obligation to law when you believe that law, as embodied in judicial decisions or in the Constitution even, is in the stark contract with the most fundamental of moral principles? Okay. So that's my ambitious topic for today. Let me start with the first and most obvious and kind of most judgment-neutral analogy between the conflicts over slavery and the conflict over abortion, and that is the sheer enormity of the issues, how important they are, and how divisive they are, or at least how divisive the opposing positions are, and how they make really strongly irreconcilable claims on each other. With slavery, that's obvious, and we all know and embrace today the moral evil of slavery. At the time of 1860, and finally by 1863, the Emancipation Proclamation, there were 4 million then living Americans in slavery. Slavery is a colossal moral evil. Do I really need to expand on the point? I have a paragraph or two about how evil slavery is, but I think that's fairly obvious today. What is less obvious and less well remembered is the array of important interests, the stakes on the other side, viewed from the perspective of pro-slavery defenders. The consequences of the abolitionist argument were equally severe, okay, equally enormous in much the ways that parallel the pro-choice positions arguments today. There was a tremendous economic stake in slavery. Property ownership in slavery amounted for a value of property ownership dwarfing all other forms of real property and personal property at the time. By some estimations, the total value of slaves by 1860, total economic monetary value, as crass as it is to think of it in those terms, was $3.5 billion, which would correspond to about $2 trillion today. Now, in terms of an economy in the mid-19th century, that means that the value of slavery was approximately 80% of the same computation of the gross domestic product of the United States at that time. That's a huge economic interest. Similarly, there was a huge cultural interest in defending slavery. Literally, and you may have heard this from Civil War histories, it was more than just about defending the institution of slavery. It was defending a way of life. It was defending a system. It was defending a series of freedoms and a whole culture. The autonomy and ability to develop a certain sort of distinctive agrarian lifestyle was utterly dependent on slavery as an institution. More than just a way of life, slavery was also defended as essential to protect the lives of the slaveholders. Given that slavery existed and that the African American population was present among us, the suggestion was that to overturn that institution would literally lead to slave revolts, retaliation, and killing. Literal human lives were at stake. Now, by the same token, obviously, from the perspective of slaves, lives were at stake too. My simple point is it was an issue of enormous consequence, dwarfing all other legal and political issues at the time. Similarly, there is no moral or public legal issue of remotely comparable importance today than the issue of abortion. Not all the time does the public recognize that, but let's just sort of evaluate the consequences. Okay. Regardless of your position on abortion, the magnitude of the issue is absolutely enormous. Right? From the perspective of pro-choice positions, this literally involves the freedom of every woman in America. Freedom, autonomy, ability to self-actualize, develop, live a productive life. The stakes from the pro-choice side are huge. Right? From the pro-life side, the stakes are equally huge. If you accept the view that abortion is the killing of a human being, actually it's hard to dispute that formulation. You can argue about legal personhood and things like that, but abortion takes the life of a living human embryo or fetus and deprives what otherwise would be a born living human person of life. So viewed from that perspective, and then taking 40 years since Roe and multiplying by between 1.2 and 1.5 million abortions, the stakes on the pro-life side are approximately that of 55 to 60 million human lives killed by abortion. You may disagree as to whether that's a proper characterization, but I think an appreciation of the stakes is that from the pro-life perspective, the stakes of the issue make it morally bigger than the combined effect of the Nazi Holocaust, Stalin's purges, Pol Pot's killing fields, and the Rwandan genocide combined. Okay. So, stakes. Okay. I don't think between the 19th century issue and the 20th century issue there's anything remotely comparable, and they are both comparable, analogous legal, moral, political issues. That brings me to the structure of the moral arguments in each case. And here I think the resemblance is really quite striking. I'm going to start with a couple of definitions. Slavery is or was the legal ownership of and complete dominion over one human being by another human being. It was a relationship in which one of the humans has all the power over the life of the other. The enslaved person had no legal rights, no legal moral status that the enslaver was bound to respect. Okay. Abortion, comparably, is the deliberate killing of a living but unborn human being for the benefit of another person. It, too, is a relationship in which one of the human beings has all the power over the life of the other. The aborted human whose life is taken has no legal human status or rights that the aborter is bound to respect. In each case, slavery and abortion, the argument for the moral propriety or allowability of such a relationship, okay, either slavery or abortion, depends on some form of the proposition that the victim or putative victim is not fully human or not properly treated as fully a member of the human family or the human community, which is what permits you to dominate it, control it, or destroy it. Okay? A part of the structure of the moral argument is the proposition that the slave and the fetus, even if arguably human, are not human life of the same kind and same moral status entitled to be protected and respected as such. I mean, I think that really is the structure of the argument. You can draw some distinctions between the two. Now, initially, there were early arguments in defense of slavery that were less aggressive. Okay, the early argument in defense of the moral allowability of slavery was that it was a necessary evil. Here we are, we have slaves. They came, you know, the Portuguese inflicted them on us. Thomas Jefferson used to argue that the King of England inflicted them upon the colonies. And we have this situation, it will eventually die away. It's a tolerable evil. It was recognized as an evil, but a necessary evil that would lapse over time. Similarly, strikingly, abortion, if you reread Roe versus Wade, as Richard Myers suggested we do, the opinion has a far different flavor than the arguments on abortion today. It has more the feeling of regret, remorse. Right? There are burdens on women. It's sort of a necessary evil. Abortion is sort of this hand-wringing. You know, we recognize that there's a moral status of this fetus. We don't wish to embrace an unqualified right to abortion, but there you have it. You know, we have to balance it. Okay. It's interesting that with both issues, over the passage of time, the positions of the defenders of the institution become somewhat more radicalized in terms of the argument they present. The later moral argument for abortion for slavery was not that it was a necessary evil, but it was actually a moral right to own slaves and a positive good, an affirmative benefit for society, a constructive social arrangement, and actually a positive good even to the enslaved poor Africans who would have had a much worse life than if they had not been brought into slavery. Now, today we all see the absurdity of that, but I think it's important to, it gives a little bit of perspective to note that that was the reality of the argument that was made at the time. Similarly, the argument for abortion rights today is less that this is a regrettable evil. Yes, we are terminating the life of a fetus, and more, this is a positive good. This is necessary and indispensable for women's lives, progress, and equality. So in both instances, the rationalization becomes necessarily a little bit more extreme as a consequence of the opposing arguments that are pressed upon it. So the argument today is that there's a necessary both for slavery and for abortion. Was it a necessary premise is that there's a not fully human status for the victim and a focus on the freedom or the concerns of the person whose conduct would be regulated. In one case, in the slave owner, in the other case, the woman seeking abortion. And today, that is embodied in the rhetoric of choice and toleration and liberty and autonomy and privacy. With respect to the slavery controversy, those had actually very remarkably similar parallels. One of the arguments in defense of slavery was Stephen Douglas's famous argument in his debates with Abraham Lincoln over popular sovereignty. He said, the principle here is freedom to choose, freedom of the people to choose the institutions they will be governed by, Therefore, in any territorial government, the decision as to whether or not it should be a slavery-permitting or a slavery-forbidding state should be up to the people. Popular sovereignty. It's hard to think of a more politically appealing rhetorical move than or now. Lincoln, of course, mocked it in his debates, referring to the great principle that if one man would enslave another, no third man should object. Fantastically called popular sovereignty. Sort of pinpricks the balloon of the rhetorical device of popular sovereignty by pointing out the reality that no one is consulting the slave as to the popular sovereignty. Similarly, with the idea of liberty, slavery was often defended as this is a freedom of people who are responsible for themselves to choose whether or not they wish to own slaves. And Lincoln does a wonderful parody of that late in his presidency when he speaks at a sanitary fair in Baltimore, Maryland in April of 1864. And he does this play on the word liberty. He says, "We all declare for liberty, but in using the same word, we do not mean the same thing. With some, the word liberty may mean for each man to do as he pleases with himself and the product of his labor. While with others, the same word may mean for some men to do as they please with other men and the product of other men's labors. Here are two not only different but incompatible things called by the same name, liberty." Then he gives a homely metaphor, which is classic Lincolnian. "The shepherd drives the wolf from the sheep's throat, for which the sheep thanks the shepherd as a liberator, while the wolf denounces him for the same act as the destroyer of liberty, especially as the sheep was a black one. Plainly, the sheep and the wolf are not agreed upon the definition of the word liberty, and precisely the same difference prevails today among us human creatures, even in the North, and all professing to love liberty. Hence, we behold the processes by which thousands are daily passing from under the yoke of bondage, hailed by some as the advance of liberty," he's referring to the Emancipation Proclamation and the abolition of slavery in Maryland, "and bewailed by others as the destruction of all liberty." Lincoln's core point is that you have to look beyond the rhetorical labels, and this is in some ways consistent with what Caitlin was saying, and look to the reality of the liberty that is being asserted. The liberty being asserted with respect to slavery is not freedom to choose, it was freedom to choose slavery. The reality of the liberty that is protected in the freedom to choose abortion is not the freedom to choose, but it is the freedom of having an abortion. Finally, another interesting historical parallel in terms of the rhetoric is the suggestion in the slavery dispute that the determination of the issue cannot properly be had by anyone other than the most affected party, meaning the slave owner. In other words, these Yankees who don't own slaves are in no position to criticize slavery as an institution. The only persons competent to do it are the ones who own slaves, because they are the most affected. It is a striking, I'm sure, unwelcome analogy to today. You see that argument many times raised that men or persons of religious conviction, that no one is qualified to play in the moral sandbox of abortion who is not someone who would be an embracer of that position. In the Civil War era, that was regarded in exactly the opposite way by the North, right? That's an interest or a bias that colors Southerners' defense of slavery. Okay? Conversely, the moral argument, the moral structure of the abolitionist arguments for abolition of slavery and abolition of abortion are, again, strikingly analogous, in that in each instance there's an emphasis on the human moral status of the affected other, emphasis on the victim rather than the person who's regulated. It's an argument about abstract moral human rights. And it has this vulnerability which the pro-slavery or pro-abortion sides make artful use of. And I call this the easy for you to say argument. Okay? And it is a little too uncomfortably easy for the pro-life side to object to abortion. And there is this vulnerability politically to the charge that not enough is done to help women. Again, that's an interesting rhetorical move, but it doesn't really address the main issue of the permissibility or the moral propriety of the act itself. It just sort of calls to account the hypocrisy of the Yankees, for whom it is much easier to condemn the institution of slavery. A related observation is what I call the inexorable logical tendency toward extremism on both sides. Okay? And I've alluded to this before. Oh my goodness, 5 minutes? I need at least 35 more minutes. No, no. The ideological premises that lead one to defend one position rather than another naturally conduce to extremism. In the case of slavery, there was the fire eaters and positive good defenders of slavery. And there's a striking North Carolina case called State versus Mann, in which the institution of slavery is held as its logical consequences to imply a complete right of the slaveholder to beat, even to the point of death, his slave. Okay? If you believe that slavery is a proper institution, you have to go all the way down the slippery slope. You see interesting analogies to that today in people who will defend, hey, if there's a right to abortion, if that's an abortion freedom, if this being has no moral status, then the right to abortion can be exercised properly for any reason. There is no justification for the state interfering to ban abortion, say, for reasons of sex selection or any other reason that people might ban proper, because it's fundamentally an intrusion upon the autonomy and it's an assault on the institution. Comparably, the logic of the anti-slavery and the anti-abortion movement does tend to conduce to extremism, and you see divisions within the pro-life movement along those lines. The analogy I'd suggest, and I'll spend 3 or 4 pages on this in the law review article, and really, Thomas, I will get to writing it, is John Brown's invasion of Harpers Ferry and fomenting of the slave insurrection through violence is almost a precise historical analog to the killing of abortionists, and is driven by the extremism of the logic that if this is human life, protecting human life from the private violence of others leads to justifiable use of force in resistance to it. I'm going to skip over the relevance and irrelevance of religion because I do want to sketch, at least briefly, the closely analogous structure of the constitutional arguments in both cases. And I refer to the obvious and parenthetically embarrassing analogy of Roe versus Wade to Dred Scott, which I've made before and which others have made before. Both Dred Scott and Roe involve 2 core premises and holdings. One is the step of denying the moral status of the person affected. Okay, in Dred Scott, the slave's moral status is denied. In Roe versus Wade, a predicate of its reaching the substantive due process holding is the initial conclusion that the fetus does not have moral status as a constitutional person or as a legal entitlement to protection. And then the second step in each instance is the use of the constitutional interpretive ruse of substantive due process. Briefly, Dred Scott has 2 holdings. The first holding is that blacks, whether slave or free, cannot be citizens of the United States. They are, to quote the opinion, beings of an inferior order, so far inferior that they have no rights that the white man is bound to respect. Strikingly, there's this analogy in Roe versus Wade where the court holds that the unborn are not persons in the whole sense. They have no rights, essentially, that born persons need to respect. Again, here there's judicial validation of that first step in the moral structural argument for abortion rights and for slavery rights. And then the second step is very familiar, okay? Substantive due process. Dred Scott is the constitutional granddaddy of the analysis of Roe versus Wade. Dred Scott's holding is that Congress may not restrict the expansion of slavery into the territory because there is a substantive due process right to own slaves, absolutely protected against governmental regulation. That should be very familiar as essentially the same made-up, atextual, unhistorical reasoning of Roe versus Wade. Now, there's much more to be said, and I hope we'll have a chance to discuss more things, but I heard the beeper go off. So I'll have to conclude with sort of a concession that this analogy, though it follows on many, many tracks, has limits, as all analogies do, right? We're lawyers and law students, and we're taught to think in terms of analogies, and sometimes it's perilous to do so. But I think this is an analogy that compels reflection and thought, because it does tend to unveil some of the premises and structure of the arguments on each side. You know, it's always perilous and sometimes trite to rely on the lessons of history, right? And I think it's Mark Twain who's misquoted as saying, history may not repeat itself, but sometimes it does rhyme. You know, there's a point to that. Roe versus Wade rhymes, metaphorically, with Dred Scott versus Sanford, in that he who says Roe has said in the previous stanza, Dred Scott. And the legal and moral arguments for abortion rights rhymes, metaphorically, with those same arguments 150 years ago in defense of slavery.